Bene, buongiorno a tutti.
Good morning, ladies and gentlemen. We're about to start this meeting, and by the way, let me thank you all for coming to this conversation. So we shall start this meeting with a very poignant title. As you know, there's quite a wide literature on the different titles of the meetings. Sometimes there's some discussion on the title, but the one for this very meeting is indeed very topical. Well, I believe that this is one of the best results that they've ever had. The title reads in Italian in a way which is a bit difficult to translate in different languages. It means that the other side of law, but in a way it is a bit of a contradiction in terms as it reads in Italian. So the other side of law, the other side of the rights, the hidden face of this huge development in the number of rights, in the role being played by rights within legislation. Talking about rights today is certainly a most topical and fashionable subject matter. It is one indeed of the one which is most frequently occurring, not just because of the movie production coming from the States, or not just because nearly all TV shows include some justice, some witness, some lawyer, some defendant. Not just because of this wide coverage by the media, but there's a deepest reason why law and rights, most specifically, have developed such a central role in the public debate. And this is due to the fact that law is some kind of practical anthropology, as it were. We might even say that if we were to understand the main values of society, what a society deem as important, what a society deem is something for which it is worth living or fighting even, well, if we want to understand this basic assumptions of a society, there are actually two ways. Either we ask a group of political scientists or scientists in general to carry out an in-depth study, which certainly is going to come about with a number of details of information, and that would end up publishing a huge book, or a much more streamlined option to understand what the basic principles of society are is to spend perhaps just an afternoon in a court, meeting up with some justices, some lawyers, some of the defendants, and some policemen, because that gives you basically the feeling. It is a bit as if in a courtroom you talk about something which is basically most interesting for a society, because this is what is worth fighting for. Now, trying to resort to another image, we can even say that the reason why we're so much interested in law, why we're so much interested in what happens in the courthouse, is that what happens in the courtroom is, in fact, a huge selfie, as it were. You know, it's taking a picture of ourselves. Is some sort of snapshot of what happens in a society. So if it is true that law or what happens in the courtroom is a bit of a selfie of the society, what is the image that we see in this snapshot, in this selfie? The image is certainly most disquieting, and it is rapidly changing as well. If we were to try and understand what society is about, looking at what happens in the courtroom, is that certainly something is changing, something very impactful even. Law certainly is one of the most important asset of society. It is one of the trademark of Europe. The major contribution that the civitas of Latin times provides to the society of the Greeks is again this is system of justice. So basically, there's a way to oppose reason to power or to overwhelming use of power. So reason is very much a constraint to the will of those who wield the power in an excessive way. Many ways have been found out to try a different way to find a solution. Either the rules of the common good are organized by means of legal system, or it is just the strongest wins it all, basically. So law, again, is developed to hinder and constrain power. And I believe that there's something which is changing in the selfie of our society. Now, there's a fact that I believe tells it all. In our common language, law has become some kind of a grammar of the public debate. All debates somewhat start off fighting for rights, asking for new rights, declaring the rights are trampled on. So again, rights are always referred to. In my region, Tuscany, in the first aid, I happened to see a poster of the Regional Health Service saying the treatment of pain is a right for the citizen. Obviously, they were talking about painkillers, but, you know, if you look at the symbol behind this statement, it's quite incredible, as if the region could grant the right to fight against the pain. And this has become the main reason, actually, why institutions exist. So when the money is over in such institutions, we don't know what to do with such rights, basically. Just think, for example, about the social rights, pensions, social health services, school, care. All the major conquests of the 20th century is that these activities that used to be charities that the civil society would deliver have become rights that are basically in the hands of the state to be distributed through the public bodies. Now the state has run out of money, so this means basically the curbing and the constraint of limit, because these are not being granted anymore. Let me close briefly before I give the floor to the speakers. At a time when social rights basically are diminished, if not denied, there's a new category of rights which is exploding. So on the one hand, those rights that are based on the relations among people are declining. There are other rights again that are exploding, and that is the category of civil rights, or what we have termed in the subtitle of our meeting, new rights. And with reference to that, let me quote a passage of a book that we've been questioning over and over during different editions. So this is a sentence by Caron on Europe. Caron states, ever since the 70s, a number of new rights have emerged with a strong acceleration of the latest 15 to 20 years. The origin of that is that desire for liberation that started in the 68. And now we talk about freedom or liberty, right to matrimony, adoption even by people of the same sex, a right of transsexuals, a right of the children not to be born unless they are healthy, right to die, and the list could go on forever. And many perceive such rights as a new conquests of civilization. Others consider that as an attack against our civilization. So much so that law has become the very heart of hot debate amongst politicians. Not just among different political parties, but within political parties themselves. Ethical subject matters are the ones that cause fighting. This is pretty peculiar. Basically, we don't find a way to solve economic problem, and yet we bear with that because then at political levels there are strong and hot debates when ethical issues are at stake. Why is that? Why is there's a strong lure? Well, each of these rights is originated in a need for parenthood, in the fear for pain and death, and the search for one's identity. Each of these rights is based on the human experience, hence they get so attractive. The thing is that we should wonder, are these rights the replies, the answers to such questions, to such demands? People's self-realization cannot be arrived at through no rights. Individuals cannot be considered as truly right if they only can enjoy all the can only be free if they are granted all rights. When people are given the right to decide when to be born and when to die, given the possibility to choose one's sex and one's identity, are we truly giving people what they look for to be free? So what is the other side of the coin then when it comes to law and rights? Well, we're still faced with this huge paradox then. Rights, basically, that had to, or the law that was that had to constrain power, is now the same. Is now used basically to remove all barriers to the wishes of mankind. So the request for new rights doesn't free people from new dependencies. As a matter of fact, it creates a huge dependence, the huge dependence of the individual on state. The state being the only one that can deliver such rights. So rights or law actually that was devised to limit the power is now the tool to actually making a power superpower, that of making people happy. Having said this much, I've tried to somehow set the context for today's discussion, and I believe that this was very much my task, that of giving food for thought. I'd like to thank most warmly our two speakers for accepting our invitation to come here and tackle the subject matter with us. Tomaso Emilio Epidendio, who's a justice and assistant to the Italian Constitutional Court. And on my right, Professor Snead, professor of the Notre Dame University, the William P. and Hazel B. White director, and director also of the Center for Ethics and Culture. I'm very grateful for you. I'm very grateful you accepted our invitation. And these are dear friends, obviously, as well as most authoritative scholars. And we're very pleased to have two different points of view. On the one hand, we're going to hear the academic point of view, the point of view of somebody who studies the phenomena of right, the phenomenon of fundamental rights, being part and parcel with ethics, personality. So in a way, law is projecting itself in this area. So Professor Snead was asked to help us looking at this and identify what is at stake. We shouldn't take it for granted that we know anything for sure about that. And Tomaso is a justice, is a judge, as we said, first and foremost. So he has a different sensitivity. His learning derives from experience, and this experience is extremely wide-ranging. He obviously has developed an important technical knowledge, as any judge should have. We've asked Tomaso to go deep down and understand what lies behind this change of sceneries, where the change of context that we're witnessing. And if there's more time, if we have more time after that, we can have an opportunity to give the floor to the speaker for a second time. Thank you.
Okay. So there's a slideshow.
Se può andare.
Perfect. Thank you. It's a great pleasure to be with you today. This is my fourth time to participate in the meeting with my very dear friend Andrea Simoncini and my new friend Judge Epidendio. Thank you to everyone who's responsible for putting this amazing event together. It's again an honor and a pleasure for me to participate. I'd like to pick up where Andrea began, which is to say an examination of the pedagogical significance of law and human rights. Put a different way, I am entirely in agreement with Andrea that if one wants to understand what a particular society or culture cares about as a normative matter, holds dear, takes seriously the goods they seek to pursue and the harms they seek to avoid, one can do a great deal of good by examining the laws and the legal discourse of that particular society. Justices of the United States Supreme Court have said that the law is a conserved repository of a culture's moral commitments. So it reflects what the culture in question cares about very much. The legal discourse reflects that. But it also does more than reflect the goods that a given society cares about. It also informs and shapes that society's commitments and their understanding of the appropriate ethical framework and what their shared life together should look like. So what I propose to do today in this conversation is to talk about the discourse of human rights as they've evolved since their development by Enlightenment political philosophers and how they have been deployed in the context of public bioethics. Public bioethics being the governance of science, medicine, and biotechnology in the name of ethical goods. And my points today are three. And in the interest of time, I'll focus more on points 2 and 3. The first point is that we, along with the Catholic Church, are right to cautiously embrace the language of human rights, the discourse of human rights. But if you reflect on the use of human rights discourse in public bioethics today, it reminds us why caution is in order, why we should be very careful and with trepidation embrace the language and rhetoric of human rights. And we must talk about and embrace the language of human rights in a way that is rooted in a rich understanding of the human person and the common good. As Andrea said, law and legal discourse, in this case the discourse of human rights, reflect something important about what we understand to be the nature of the human person and the nature of the common good. And there are a number of dangers in modern human rights rhetoric on these points. That is, human rights as they've developed over time in the modern era risk the possibility of reliance on a picture of the human person and the common good, which is false, impoverished, thin, and reductive. And we must avoid those pitfalls, those perils, when we embrace the language of human rights. So let me begin by underscoring the good and the importance of human rights as a conceptual matter. And then I'll move on to reasons for caution. Human rights as a concept is a culturally powerful way of capturing the intrinsic, pre-political, inalienable dignity of every member of the human family. Human rights are not conferred by the state, nor can they be taken away. They create an absolute minimum standard of care and protection for all members of the human family in the face of dehumanizing and destructive threats by the powerful. So it shouldn't be surprising that the era of human rights emerged, the modern human rights, emerged in response to horrible atrocities by totalitarian regimes in the 20th century. So human rights are important, and I want to be clear that we, as Catholics and as persons of goodwill, should embrace the language and the concept of human rights. However, there are reasons to be skeptical and concerned and cautious in embracing human rights as described and discussed today. And the reasons for caution are particularly clear when one considers the discourse of public bioethics, especially on matters relating to abortion, assisted reproductive technologies, and embryo research. And I'll take up one of those three issues as I illustrate why I believe there are reasons for serious vigilance and caution in our embrace of human rights. Put briefly, there are two problems that should concern us. I'll focus mostly on the second, but I'll mention the first because it's also important. The first problem in human rights discourse is what I will call the problem of origins and justification. Where do human rights come from? Why should we respect them? The second problem, more deeply, is the problem that Andrea referred to as practical anthropology or moral anthropology. That is, what are the premises about the identity and nature of the human person and the nature of human flourishing and our shared life together that ground modern human rights discourse? And there is a deep peril, a deep danger of a reductive understanding of the person as a radical, isolated, atomized individual will who has no necessary obligations or relations to other in society, whose highest good is simply to pursue the projects of his own desires. I think if we consult our own experience of our lives, both individually and together, this is a false picture of the human person. And so we should strive to avoid the risks in talking about human rights of embracing that impoverished vision of the human person and of our shared life together. And this problem is particularly acute in the context of public bioethics. So the first problem that I mentioned, the problem of origins, I won't reflect on very long, but it's important to say that there is disagreement and ambiguity about why human rights are binding, what their content is, and what their sources are. Jacques Maritain, very famous Catholic philosopher, who was instrumental in persuading the church to take a more favorable view towards human rights discourse in the wake of World War II. He was involved in the creation of the Declaration of Human Rights in 1948, was explaining how it was possible for a group of individual leaders, world leaders and thought leaders who disagreed profoundly about fundamental questions to agree on the concept of human rights. And Jacques Maritain said, "We agree on these rights provided we are not asked why." And you can see in that pithy quote the problem of origin and sources in a pluralistic community. There are many different sources that have been proposed to ground human rights. We don't need to talk about that. What I would like to focus on are the deeper problems with rights talk, specifically as it emerges in the area of public bioethics. The question, first of all, in human rights, of who is the human that is the bearer of these human rights, and the problem of radical individualism. And then secondarily, what are rights for? What is the picture of human flourishing that we should embrace, and what is this problem of relativism that we should be careful of to avoid? So, those political philosophers during the Enlightenment era who developed the modern conception of human rights seem to ground their conceptions of rights in an image of the individual human being, the individual person, again, that is conceives of the individual as alone, solitary, antagonistic, vulnerable, who needs rights to essentially and fundamentally protect him and his belongings from assaults by others. The person in this framework is conceived as radically alone, not born in relation, not naturally social, not naturally connected to others. The person is conceived primarily and fundamentally as a will. That is, what makes an individual special and what defines a person is his or her will, his or her cluster of desires and objects of their desire. And the body, and this becomes important in the context of public bioethics, is merely an instrument to the pursuit of the objects of one's will. The body is purely instrumental. There's nothing important or special about the unity of mind and body. So there's a kind of what philosophers call substance dualism, radical separation of mind and body, with an emphasis on the mind as being important and the body as being secondary and instrumental. Individual persons are conceived simply as rational choosers. That is, individual consumers who see the world, again, externally as a mere instrument to the pursuit of the desires of their own construction. Social relationships in this worldview of radical individualism are similarly instrumental. And relationships to others are simply adjuncts or tools to achieving the desire of one's will. The highest good for the person in this framework of radical individualism, the height of human flourishing, is the pursuit of projects of one's own construction. There's no nature, there's no teleology, to take another philosophical term. It is simply what one desires, the projects that one constructs for him or herself. And you can see in this image this vision of radical autonomy and radical individualism that is at the heart of this distorted and impoverished understanding of the person in social relations. There are no natural restraints on the will or on desire. The individual is literally a tabula rasa. There is no natural constraint, there's no teleological constraint. Personal relationships are merely instrumental and contractual. I come together with people that I meet, and we make agreements to pursue the projects of our own making. When it's no longer beneficial for us to be together, we can break apart. But consent and contract is the form of all relationship. There is no such thing as an unchosen obligation. There are no people who have claims on me and my concern and my aid who I do not freely accept in a relationship in that way. And you can see here the image of, it's a community of strangers. It's a community of strangers who come together for utilitarian reasons, for mutual benefit. Persons in this impoverished framework are isolated adversaries that are clad in the armor of their rights. This vision of human rights separates us. It sets us against one another, focusing on what distinguishes and divides rather than what binds us together. The ethical goods, as you can see and you can imagine, the highest ethical good in such a framework is autonomy. The highest good to which all other goods are subordinated. An injustice is conceived of as any constraint on the freedom to pursue the projects of one's own choosing. And the role of governance and our social life together, the primary good is to remove constraints, public constraints, private constraints, natural constraints, and to otherwise provide the conditions for the assertion of the unencumbered individual self. And this is particularly evident, these risks, this impoverished vision of the person is evident in the human rights discourse of public bioethics. In public bioethics, as you'll see, I'll take one example in the interest of time, assisted reproductive technology. But across the issues in public bioethics, abortion, contraception, assisted reproduction, embryo destructive research, end-of-life decision-making, any issue in public bioethics, people talk about human rights in ways that reflect this vision of radical individualism. Persons are conceived primarily as autonomous individual wills. Social relationships are instrumental means of achieving one's desires for freedom, as in abortion, for an idealized family, as in contraception and assisted reproduction, or for an overbroad conception of health, as is the case in the discussion of embryo research. The only binding human relations are those that are freely chosen. And even children and family are understood through the lens of the will, a project freely chosen or rejected for our own purposes, sometimes with the aid of technology. And I'll just take one example, not abortion. I'll focus on the question of contraception and assisted reproduction, specifically assisted reproduction. In the arguments, the human rights-based arguments for the maximal access and use of assisted reproductive technologies are framed in terms of autonomy. They serve the choice to pursue or avoid procreation, which is essential to self-definition, the pursuit of desires, and self-expression. One pioneer of assisted reproductive medicine, Dr. Gerald Shatton, described the goal of assisted reproductive technology, the ethical good at the heart of assisted reproductive technology, is to help parents realize their dream of a disease-free legacy. Where is the child in this picture? The child is a project, the object of the parent's will. The child is a vessel into which the parent pours his or her aspirations. The child is a product to be accepted or rejected to the extent that it matches the parent's desires. Take a look at the way these matters are discussed in American and, I gather, Italian and European and worldwide public bioethics. Contraception. Here you see an ad for contraception. You notice the woman says, "This is my baby right now." It's a cello coming down a child's slide. This woman's baby is an expensive camera on a tripod. So the baby, the child, is analogized to a hobby, a project, the object of will. You see this in the discussion and discourse over sex selection in assisted reproductive technologies, where male children are favored products to be accepted, and female children are rejected and discarded. You see eugenics and genetic screening and selection and the discussion of those practices and techniques in the field of assisted reproductive technology. Here's an ad to build a baby. Choose your baby's sex. Great range of skin tones. Minimum height guaranteed. That particularly is offensive to me as a person of short stature. Disease-free. There's nothing wrong with designer babies. Human cloning is discussed in very much the same way. Advocates of human cloning. And most recently, You may be aware of the story from Australia, in which this couple contracted with this woman to bear 2 surrogate children, one of whom was healthy, one of whom had Down syndrome. This baby had Down syndrome. That's baby Gammy. This baby was rejected by the parents as not meeting the standard of quality that they had contracted for and hoped and expected. Again, this reflects in a very stark way the radical individualism and diminished conception of human flourishing at the heart of a wrong-headed understanding of human rights. So, what do we do? Should we abandon human rights as a failed project, as terribly infected by this wrong-headed understanding of what human beings are and what human flourishing is? I would say no. I would say we must embrace the concept of human rights for all the reasons that I began with. It's uniquely valuable. It's a valuable language, especially in a pluralistic culture, to talk about why we're important, why human beings are inviolable, why human beings are irreplaceable. In order to correct this, and I'll wrap up very quickly here, in order to correct these risks and perils embedded in rights talk, especially in public bioethics, we have to retrieve and promote a richer understanding of persons, a richer conception of human flourishing. And we have to take seriously what Don Caron said about the human heart and desires and these explosion and proliferation of rights to health, right to autonomy, all these different rights in the context of assisted reproduction are grounded in legitimate and normal and natural human desires. But we have to be careful that they don't become distorted and perverted. And to do so, we have to model for others, and also in our speech and in our discourse, reflect the idea that persons are all equal in dignity. Each person is intrinsically equal in basic dignity simply because of who he or she is as a member of the human family. Everyone, every human being, from conception to natural death, is valuable and irreplaceable, regardless of her age, size, location, race, sex, usefulness or burdensomeness to others, or the possession or lack of certain favored capacities. And by contrast, it's morally incoherent and a grave injustice to exclude from the circle of persons and the protection of the law those who are immature, small, dependent, or incapable of high-level cognition. And reject the idea that there's any such thing as a human non-person. And that our relationships to one another are not merely instrumental, but rather we come into the world situated in relation to others, with connections of kinship to past, present, and future generations. We do not come into the world as radical individuals, unconnected to other members of the human community. We are not merely disembodied wills, but we are profoundly vulnerable, needy, and embodied living organisms. And from the beginning, we rely on one another for basic survival. And we have a reciprocal duty of care to all members of the human family. People have claims on me that I have no knowledge of or even positive feeling towards. People have claims on my care and protection regardless of my choosing. And I have claims on them regardless of their choosing. And we have to share the beauty of this vision and transmit the beauty of this vision of who we are and what we owe to one another with integrity and wholeness, particularly as it relates to procreation, family, the purposes of scientific inquiry, the ends of medicine, and the provision of essential health care. And this is what we should work towards in our discussion of human rights within the frame of public bioethics and in all legal contexts. So thank you very much.
Ringrazio Carter Snead per questo.
Thank you, Professor Snead. Thank you for this major overview. You certainly magnified the selfie. You provided a lot of details to identify this ambiguity. What can be, again, the other side of the coin? What can be the other side of this, of the law and of the fundamental rights? And now I'd like to give the floor to somebody who has a direct experience of this subject matter. He indeed has an hands-on experience with such rights. And having said as much, I'd like to give the floor right away to Tomaso Epidendio. Thank you. Thank you very much for giving me this opportunity to come to the meeting. I shall talk about this subject matter in my own perspective, obviously, i.e., as somebody who has had a 20-year experience with law. We're talking about new rights. But first of all, let me state what new rights are. As a matter of fact, this is a pretty generical phrase with which we usually refer to those rights who've been claimed and recognized or acknowledged over the past decades by Western political institutions. And this is something that we tend to be proud of. And there's an additional feature that I appreciated in my own stance, in my own position. Oftentimes, these new rights, before being recognized by the public entities, are recognized usually by jurisdictional bodies. So they are usually detected by the judges first, basically, and indeed we find reference to that in the judgments by the Italian Constitutional Court. We have the judgments that we often are covered by the media of supranational courts as the Court of Strasbourg or the Court of Justice of the EU. So this is a new element. Basically, these rights are recognized basically by jurisdictional bodies. So they usually don't develop in the parliament, in the public debate, but usually they are first anticipated by the courts. Now, I'd like to refer to what the website says about the meeting. I'd like to tackle this not very much as an enemy to fight against, because what I'd like to state right from the beginning is that amongst these new rights, they are not all to be fought against, to fight against. There are many that are, again, they are valuable. Professor Snead indeed referred to a number: the right to terminate one's life, the right to abortion, right to have union marriages among the people between people of the same sex, right to have children. So whenever we look at something as an enemy, it might make us miss the objective. So I'd like to somehow refer to this subject in a provocative manner. So to react to a provocation, you have to start with facts. And facts are to be looked at, straight in the face. There was one episode that I'd like to identify and reference to has already been made by Professor Snead, i.e. 1975. In 1975, the Pontifical Committee, Justitia and Pax, drafted a document, i.e. the Church and the Rights of Man, human rights, where there's a clear indication of a pastoral level on the rights of man, which had to be based on the dignity of human dignity. After a lot of caution, but therefore, the Church seemed to join in the idea that the discourse of human rights is fundamental in the moral progress of mankind. And this is an important fact, again, because in 1975, the lay culture and the religious culture, or the Catholic culture, seems to coincide in stating that the human rights discourse can become some kind of lingua franca in the global public debate, by means of which anybody in whatever country, hence the dissemination of these rights away from the Western world, so irrespective of the legislation in their countries, can see one's right protected based on an elementary experience, i.e. the dignity of the person. So lay culture and Catholic culture seem to believe that this discourse, that this common language can lead to peace and consensus. Maritain has just been quoted. We could also quote Bobbio, Norberto Bobbio. And these stances, as a matter of fact, are perfectly overlapping at times. Let's fast forward and let's look at rights as the rights to dignity that are necessarily to be shared. But then there are also controversies, though. There are even public demonstrations in certain countries. There are those supporting a right to those supporting another right. So there is a contrast. That's at the time of the other side of rights, or rights against. This is what is provocative about today's reality. What happened over the past 30 years, therefore, between 1975 and nowadays? I think I'd like to use an image to make myself clearer. There's a cartoon, Fantasia, by Disney. And there's the wizard. There's Mickey Mouse that is a slave to a witch, to a wizard, that reads maps, and the wizard closes the book, goes to rest, and asks Mickey Mouse basically to clean the castle. At that point, there's a small slave, this Mickey Mouse, that charmed by the possibility, or attracted by the possibility that the big book with the magic formula can grant him, uses the magic language and animates the broom and the other instruments so as to carry out the cleaning, basically. And then he sleeps, imagining that everything is done. And then he wakes up all of a sudden because the broom and the bucket still brings water on and keeps on doing that, and the little Mickey Mouse cannot stop them doing that. So at some stage he tried to axe it out, and then the situation is further worsened because you have a multiplication of buckets and brooms, and the situation again is greatly worsened and exacerbated. So I believe that the risk with human rights is a bit what happened to Mickey Mouse with the wizard book, with the sorcerer's apprentice. At times, we devise rights when those are not necessary. For example, Mickey Mouse is resorting to the big book just to carry out the cleaning of the castle, and there would have been no need for that. Then there is this the paroxysms of the multiplication of buckets and brooms. The temptation is to react with violence, and that violence could be, for example, the violence of banning. So there's this opposition that with rights can be a ban on that rights, and thus further worsen the situation. And as happened in the cartoon, the situation with the castle is further worsened. So I'm not going to talk against rights, because I believe that the risk would be that of having the multiplication of the above. That of rights is a language. It cannot be termed as good or wrong. It's something that could be good in certain contexts, also in time contexts, and certainly the situation has greatly changed if we compare the situation today to what it was in the 70s. So rights also change depending not just on the time frame, but also depending on who's using them, who's in the hands of whom they are placed. Rights basically are shaped as promises. The right is a promise issued by the state to satisfy a wish. And Professor Simoncini was very right when he referred to what he read in that poster by the Tuscan region. Everybody would be happy to guarantee the right not to suffer any pain. Obviously, this language talks to the deepest part in our souls. It is irresistible indeed. To do away with pain altogether would be the dream of everybody. And this is a promise issued by a regional authority. It seemed that promises would cost very little. But meeting such desires seems something that doesn't create any problems, as if law wouldn't cause any pain. And this, unfortunately, is the reason why there are so many uncomfortable rights. What's wrong in recognizing a certain right? What is there to lose? There's just something that somebody else can gain from a certain right. So the myth of mild law can bind with the non-discussion of the origins and foundations. So, by the way, in the second half of the past century, Maritain and Bobbio, for example, agreed on the need that there's no need to question oneself, and I'm going to obviously cut a long story short, on the origins, on the basics, on the fundamentals. What's important is to grant rights the adequate protection. And this is the starting point. This is the might, the strength, and the weakness at the same time of the human rights discourse. With the human rights discourse, I focus my attention on the value that a certain good may have for mankind. And basically, I espouse, with that view whereby a law or a piece of law could say anything, thus leading is taken to extremes to totalitarianism. Few dictatorships actually got to their position without some kind of validity. So there's a positive value when you stress a right, because it stresses the importance of value, but in the same way, it doesn't make the disadvantages visible, those disadvantages that are closely correlated with the advantages that are shed very much light on. As Professor Snead said, there's the value which is very strong and which is recognized for the individual. That's this exaggerated concentration on the individual, on the person, and every right can be translated into a very individualized kind of discourse. It doesn't say actually all rights don't say who are obliged to do what and how that imposition is carried out. This is the so-called rhetoric of rights. And rhetoric is nothing negative. It has to do with the good use of words. But, there's just one stance that can be clearly identified with other things being neglected. So there are things that are always neglected when you voice a right. For example, a right to have a child. There's a basic ambiguity there. Because I may be saying many things when I say that somebody has a right to have a child. I could even say, for example, that there's a right of couples to enjoy no constraint whenever they want to have a child. So it could be, for example, such a right could be a true freedom in that every couple can oppose the will of a state to curb the number of newborns. The right to a child could mean also resorting to assisted reproductive technologies so as to enable couples that naturally cannot bear children to actually do bear children. So based with a power, there's somebody whose interests are neglected, i.e. the child. Resorting to ART, to the new technologies, we could have a multiplication of parenthood. Not only do we have basically the natural mother, the mother that has born the child, but there's going to be also the genetic mother on the one hand, the genetic father, the natural mother that has actually delivered the child. And then there could be the legal mother that has entrusted another woman to deliver a child that genetically belongs to her. So all these multiplicity of subjects in a way, or if individuals are involved. But when you look at the right as it is drafted, you may not think about all that. A right to a child could also refer to something different, i.e. The right to a child, which is a product. As Professor Snead was said, the state therefore has a duty to grant me a child. The state should pay for ARTs or should find me some kind of child, or even through adoption. That's why this French scholar of the 20th century, he said that rights promise the infinite. They are totally unfettered, and you are bound to be disappointed because there's obviously no end to wishes, and you can never think that all your wishes and desires are actually met. So what can we do with a positive approach? Well, I believe that right from the beginning, the debate should be focused on what is not said whenever a right is voiced. And this should be done immediately. So there should be a debate on the costs, for example, quantity-wise and quality-wise, in terms of loss of freedom on the number of some, and constraint and limitation of other rights. And as a matter of fact, our job is not that difficult because reality does away with ideological traps. Think, for example, about the Ilva case. It seemed it was just a matter of right to health. There was apparently there was a myth of the individual right, of the single right to health. But as a matter of fact, that right was not isolated. There was a right to a job, and certain problems had been caused also because there was an opposition or was a contest among rights, and the rights were good for some and bad for others. We should also look at the quantitative costs. And I'd like to quote an example referring to what has happened during the last few days. Think about the tragedy of immigration. who wouldn't like to put an end to the number of casualties caused by migration? There are subjects that promoting right and others that have to bear for that because there's always a cost associated with any right. And now a decision has to be made. So, if we succeed not in resorting to bans, not in banning anybody, because if we do that, we might seem as if we are imposing something negative. It's certainly going to be experienced as something negative, as a limitation, as curbing freedom. But if right from the beginning, whenever a right is voiced, if we talk immediately about who's going to enjoy some benefit and who's going to pay for the consequences, think about the swapping of embryos in the hospital in Italy. Well, there's a way to control that, but there are no ways to do that by means of these courtrooms, because courtrooms are not there to issue laws. We're there to implement the law. There are costs, basically, in terms of quality, i.e. the limitation of other rights, loss of other liberties by somebody else, and there are also quantitative losses. So whenever a new right emerges, we should always look at the disadvantages that right can cause to somebody else. There has been a booming of rights. But we should question, therefore, the basic issue whereby we shouldn't talk about fundamental issues. There's a latest issue of one of the most important journals of philosophy and law, Ars Interpretandi, is fully devoted to value and legal argument. This is indeed the upcoming subject. Going back to talk about values is a good thing. We have to talk about values. This is for sure. But there again, there's an ideological trap that is hidden just around the corner. And what is that trap about? There's a risk of going from one extreme to the other. At the beginning of the 20th century, we started off with a positive approach on the part of the legislators, whereby there should have been a total separation of law and morale and ethics, and we are approaching now the other extreme, whereby law and ethics are fully identified or are considered as one single thing. And this is certainly a challenge that is put to us as Catholics, because its ethics is considered as fully overlapping with law, basically implies going back to the ancient times. As happened in the 70s, there's going to be a convergence of the different cultures leading again to this kind of identification whereby everything should be termed into legal terms. But we won't agree on the ethics becoming law, because there's going to be an elitarian ethics as identified by the judges. This is the risk for the third millennia. And I believe that there's a good suggestion that we should find, and just a few minutes before I'm done, to refer to quote a book. that probably hasn't been as successful as other books published by the Pope. Corruzione y pecado, corruption and sin, and in Italy it is translated as to treat corruption. And this is something that the Pope wrote as a cardinal. This is my own personal interpretation, so I would term this as the metodo Bergoglio, the Bergoglio method. The Pope started off referring to a case that emerged in Argentina, and again I'm going the Catamarca case, the killing of a young student attending a religious school. And then the trial, there was a number of public politicians that, in a way, stopped the investigations from going any further because apparently the so-called children of the politicians were involved in that killing. So the starting point, it seems to be as a pretty legal case, institutional corruption, whereby again the politicians stopped the investigation because the children of important people were involved in the killing of this girl. But there's a dimension where law, as its own meaning, of course, law has a cost. We always have to be reminded that when we talk about turning everything into legal terms, we shall not forget that there's always a cost associated with law, and that is the use of strength. So this myth of mild law has created some kind of confusion. I never stated in my courtroom any cost without somebody, crying for that, because there's always a cost associated with law. Whenever you resort to the strength of law, it means that I have to oblige somebody to do something, and this obviously represent a cost that has to be borne, especially when you have to protect against the violence of somebody else. But those who are resorting to force and strength and putting a limit to other people's freedom, that has to be the last chance, the last resort. The Pope obviously acknowledges that you have to protect yourself against the violence. Even social demonstrations, there were also silent demonstrations in Argentina. Nothing would have happened if this nun in this religious school hadn't gone with other people, and this scandal had emerged, eliciting the conscience of many people in Argentina to question again what was happening, to question themselves about again what was actually happening there. But there's a take-home message after reading this book that is extremely, it is just 50 pages, but it's a true treatise of political theology of this millennium. It seems to be pretty streamlined, but as a matter of fact, it is quite deep and meaningful. The basic assumption is that there's a perfect continuity between corruption of the heart and institutional corruption. The understanding of corruption by the Pope is certainly what embracing concept. I hope I'm not betraying the thinking or the speculation by the Pope, and so you should read it and obviously not rely on what I'm saying, but what I can provide you with as interpretation of his words. He looked at the corruption as a metaphysical immanent element. Corruption is the decomposition of the natural world, of the fallen individual and the institutions alike. There's a decomposition process that involves institutions themselves, and such decomposition entails the loss of the capability of being, growing, serving. And what is the solution as issued by the Pope? Well, it could be termed as some kind of anthropological phenomenology of corruption. anthropological phenomenology. He identifies what are the distinctive traits in the character of the corrupt man, so that each of us can look at what we do, recognizing what corrupt people don't realize, i.e. to be sick at heart. Now, unfortunately, there's not the time for me to go into further detail, but I assure you that this book is quite extraordinary because it suggests, again, deep down speculation for us to carry out in our daily life. So this is the take-home message of this book, but there's another one that I should add to that. The Pope at some stage in this book, after stating something very forceful, says, for corruption there's no forgiving, but for committing sin there is. Because those who are corrupted don't realize they make any sin, so they don't ask for pardon because they don't realize they're actually perpetrating any crime. And as a matter of fact, they do the opposite. They believe that all friends should be their accomplices. And there's a very thin line between accomplice and friend. And this is especially confused for those who are corrupt. They don't realize that they perpetrate crimes when they do so. Corruption is nothing but a hope that becomes imminent in the virtual future of the successes that are pursued. I believe that my interpretation reads as follows. We want everything now. And here, hic and nunc. So there's also corruption with rights. There's a loss of the transcendent horizon with rights. If we lose this horizon, if you want to make everything imminent, then rights becomes idle. There's a total identification of the ethics with law, and that faces us with rights regarding to that can be said about other things, i.e. that rights are based on assumptions that cannot always be granted. Thank you.
Well, thank you very much. Thank you very much, Tomaso, for this really deep presentation. I think that you really could give a really new contribution, i.e. the idea which says that corruption can affect the rights. We only have a few minutes now. I'd like to give the floor again to our speakers because their comments have been really interesting. Just a statement, a final comment. The first thing that emerges from this discussion is that the new rights have not been demonized, as it were, which is a very widespread position. It is as if we are here available to pick up the challenge. Whenever we are offered new things in modernity, we can either defend ourselves or be involved. So my question, which are the positive elements of this challenge in the modern world, starting from Carter? As you are very knowledgeable in this sector, how can we promote through the defense of rights a culture which is not an anthropological assumption. Do you think that there is a way to use these tools to see to it that there is no ideologization, so there is only one winning culture? Do you think that we have some tools to do that?
Yes. I think that as you began your remarks at the very beginning of this session, you talked about how law and legal discourse and rights reflect the self, the sort of selfie image that you used, but also the things that we hold dear and we care about. I think that we have to be attentive when we make law or interpret the law, in the case of a judge, in the area of public bioethics, for example. And I'll take the example of assisted reproductive technologies, which I focused on during my remarks, to do so in a way that captures the richness and the complexity of not just the human person, but of social relations and our shared life together. So, by way of a concrete proposal, it seems to me that in my country, where there's no legal restrictions as such on the practice of assisted reproductive technology, in your country, where there were some but were invalidated by your constitutional court not long ago, it seems to me, without giving concrete legislative proposals, my view is that we should construct the law in a way that reflects the reality and the richness of the persons involved. So most obviously, it seems to me that the law should recognize and reflect the fact that centrally involved in the practice of assisted reproductive technology is a child. It's a child, not a product. It's a child. It's a gift. It's a gift that's to be welcomed unconditionally. My old mentor, Leon Cass, described a newborn as a mysterious stranger that we welcome and love unconditionally. It seems to me that the law should be constructed in a way that is coherent with that truth and doesn't do violence to it, that doesn't transform the child into a product that can be returned if it doesn't meet your expectations as a consumer, that doesn't treat the mother who's being treated by a physician as a consumer, but rather as a patient, that doesn't treat the physician as a mere provider of goods and services, but rather one who exists in human relation with the mother and the child, with the obligations of care to both, and whose job it is to serve the health of both. And even the concept of health in the law should be reflected in all of its richness and complexity as the physical good of the individuals involved, not simply the object of their desires. So you don't get something, abortion doesn't become a form of preventative service. A child is not a disease to be prevented. A child is a human being with his or her own identity. And we should also think about how we regulate and organize healthcare so that we can construct a society in which people have access to healthcare and essential medicines, and so the parents, and particularly women, don't have to make a dramatic, deforming choice between a career and a professional life with no children versus foregoing those possibilities or having to turn to, in some cases, dangerous and dehumanizing technologies to try to realize their dream of children later when it becomes more difficult. And then finally, the law should reflect a society that welcomes children, that supports families, women, men, and also, again, provides for their basic needs, healthcare, especially in the area relating to this particular field. So the law should, so that's a very long way of saying that the law should reflect and inform the population in the richest way about who persons are, what we owe to one another, and what the nature of our shared life together should look like.
Thank you. Grazie. Grazie per questo, sebbene flash.
Thank you very much. Now, the floor to Tomaso for the conclusions. Well, I have described my idea what we can do strategically in the long term, but I also would like to say something about the short term by starting from a very simple example. I said that the law has nothing absolute. It's a language which can be good or bad, so its rules should not be overestimated. At the same time, we have to come to terms that recognizing rights in a democracy is played in the relationship between majorities and minorities, and sometimes we are part of the minority group. Let's start from a burning issue, i.e. The marriage between people of the same gender. If we acknowledge such a right from the point of view of those who share certain values, may and have and has a special effect, encouraging a number of behaviors and to forge a certain type of society. I'd like to be provocative. I would not be very much concerned about that, because in the end it's a reality that wins. There are some rhetorical artifacts, isolated rights and so on. In the end, they were unveiled. So sooner or later, certain ideas on the structure of the family will be asserted in the reality. But what is the real battle to be fought now is that, when mild rights show their angry face, for example, when you think of preventing the use of certain words, because they indeed refer to a specific gender. That is an invasion of freedom. I mean, one thing is the law of the state, which is the law, has nothing to do with morale, which does not prevent my freedom to the end. So, Eliot, we should not dream of perfect systems so that it becomes useless to be good. What's important for the law is not to deny my freedom, because it's there that we have to defend ourselves. That is the no-return point of the law. And that brings me to the issue of legitimacy. We should speak of legitimacy in this field. This, in my opinion, is the response in the short term. So we should bear in mind the context, highlighting one of the key values in which I believe, the role of freedom of man. So there will be a dimension where the giving examples, testimony, will be much stronger than legal battle. There will be cases in which the organized violence of indeed working on right will prevent a certain freedom, and then that will turn into something which is illegitimate. Well, thank you very much. Well, these events, these meetings, during the meeting of Rimini are very important, because our speakers do not come to repeat prepared speeches. They are here to have a dialogue. These are opportunities to learn, which are becoming increasingly rare in our society. I paid a lot of attention to their words, and we have tried to face the issue of new rights and the other side of law in a pretty uncommon way. We indeed have not used bombastic words which are used in the public discourse today. So we have been proposed indeed a new perspective, an original one. We are indeed at the beginning, but the new rights are there something to be criticized right from the start? No, because they are the result of a demand. So the issue is not the question or the demand. The issue is whether there is a road to an answer. Is it wrong for a mother to advocate that the baby is born without diseases? We cannot say that. Indeed, no mother would say, I'm not concerned, or I would accept that my baby is ill. No. Can we think that a person which is conceived without diseases could be happy? Absence of disease, does it mean happiness? And what is the cost that we are available to pay to have a child free of diseases? Indeed, Tomaso illustrated that very well, and Carter gave a very interesting picture. So any right has its cost. The idea that rights can be developed without having someone receiving obligations is not immoral. It's simply unreasonable. This, in my opinion, is the very interesting contribution that we have given to this discourse, asking this question, i.e., what is the real dimension of human rights or the new rights which are being developed today, and asking what are the costs implied in these rights, what is the terrible face of these rights, or terrible side. And we cannot do without asking this question, i.e., what is the reasonable impact of regulating certain rights on the society? The society thinks of these rights simply by caring of them without being able to realize who are the subjects, who will have new obligations. Well, there is an issue of rationality, i.e. using the reasoning in the public discussion. And hence, we need to be able to reasonably anticipate the impacts that certain rights will have on the society. So we are all invited to a reasonable public discussion. As Pope Benedict XVI said in front of the German Parliament. It's not an issue of transposing moral principles in the legal discussion. We have to wonder where is the reason in that discussion. One might say this is a weak position. Appealing to the heart means being weak. We should take sides clearly, and I conclude by reading a quotation. I was very much impressed by this, and Carter confirmed that by speaking of the idea of playing a role when recognizing the society and not forging it. The stubbornness of reality mentioned by Tomaso, the idea of testimony. Well, the space for testimony is a loser. I mean, we need to fight on the arenas. Father Pizzaballa said, we often hear desperate declarations on the situation. Apparently, we are close to the end of everything. Maybe the old models have come to an end, but the world is not over. However, it's not uncommon to hear from our people and religious persons words of discomfort and resignation. We speak of clash of civilizations, and it's like invoking everyone to pick up the arms to defend. This has nothing to do with the Christian faith. We are forgetting a key element. Christianity was born from the cross and cannot do without it. Jesus becomes the King of the world after being hung on the cross. So Christianity is the result of failure, of transfixed heart. When we speak of the power of the heart, we should look at the heart, which is the measure of the love of God and our love. And our actions of Christians should be tailored and measured to that heart. So this is what I advocate. It's good that this discussion bears in mind the heart mentioned by the Pope when he spoke about the corruption. And this is the point from which we can restart. Thank you very much. We are pretty late, so enjoy your lunch. Thank you very much.